We've done applications for medical marijuana dispensaries, cultivation sites, manufacturing facilities. We advise people on the regulatory landscape on things like industrial hemp and CBD. So I'm happy to be here and hopefully have something to contribute.
Absolutely. Well, your introduction segues us into what we're going to be talking about. So we're going to take a break from all the COVID-19 information here that's been disseminated on a daily basis. We're actually going to talk about another hot topic that I like to talk about, and that's medical marijuana. And actually how I linked up with Dylan is this case that just came before the Supreme Court and was just decided, Wild versus Carriage Funeral Holdings, with regards to the Compassionate Use Medical Marijuana Act that was set forth in 2010. Dylan, I know that you were a part of that case. Do you want to tell everyone what that was about?
Yeah, absolutely, Wendy. So, shameless plug. I'm lucky enough to be working at a firm that has dedicated itself to some public interest matters, and in fact, we just opened a public interest center recently. So we do quite a bit of amicus work, and in this particular case, we argued on behalf of the ACLU of New Jersey. So just to give you some background about the case, Mr. Wild was a funeral director at a funeral home. And unfortunately for Mr. Wild, he was suffering from cancer at the time. So he went to see his doctors, he got a valid prescription and started using medical marijuana. He was using the marijuana for about a year without incident, maybe a little bit more than a year. And on one occasion, he was involved in a motor vehicle accident within the scope of his employment. And the company had a policy to drug test employees who were involved in accidents. So at the time he was going to provide his sample for the drug test, he told his employer at that time, I have this medical marijuana card, I'm suffering from cancer, and this is a medication that I'm using that really alleviates a lot of my symptoms. So after telling his employers this, they allowed him to work, I think, 2 more funerals that he directed after that, until, I guess, corporate headquarters had made the decision to terminate him. So Mr. Wild filed an, yeah.
Oh, no, oh, good. I was just going to say, one of the things that I thought was interesting about the his use of medical marijuana is that he wasn't actually asking for accommodation at that time, correct? That's why he didn't tell anybody. He was using it after hours when he wasn't home. Right,
and that ended up being a big factor in this case. So I think that's a good point, Wendy. To inject that here. This was not somebody who was going into work and smoking a joint at his lunch break and then coming back in. This was somebody who was using marijuana at home medically at night after work hours, and he would come in the next day and be totally functional, able to perform his job duties. Nonetheless, there was a corporate policy and he was terminated. So he did file an action under the law against discrimination against the funeral home. The case was in Bergen County, and at the trial level, it was dismissed on the grounds that the Compassionate Use Act, Section 6I, I believe it was, before the amendment, essentially stated that nothing in the Compassionate Use Act will require an employer to accommodate the use of marijuana in the workplace. And that last phrase really became the operative phrase in this case, in the workplace. So,
because the Compassionate Use Act before, and there were changes while this case was pending, is that it didn't require employers to make accommodations on the job, which is sort of where I saw the conflict between the Compassionate Use Medical Marijuana Act and the laws against discrimination. Is that accurate?
Yeah. I mean, I don't agree with the representation that it's in conflict, but I do see there was some tension there, perhaps. But really,
they changed the law.
right. Yeah, now we have a new statutory framework. But what I found interesting about that is, the Compassionate Use Act really has nothing to do with employment law in any way, shape, or form, other than that one provision that was thrown into this law. Which, did it really belong in that law? Possibly. Could it have been written directly into the law against discrimination and cross-reference? That could have been another way for them to do it if they truly intended employers not to have to accommodate it at all. So after Mr. Wild's case was dismissed in the trial court, he did file an appeal. And what the appellate division held is that, you know, these two statutory frameworks, you have the law against discrimination on one hand and the Compassionate Use Act on the other, that they're not in conflict, that when you interpret these two statutes, you can interpret them to be read in harmony. And so what the appellate division held is that while nothing in the Compassionate Use Act requires an employer to accommodate marijuana use in the workplace during work hours, that does not mean that they don't have to accommodate the use of medical marijuana after work hours. And so that,
oh, go ahead.
yeah, so that's generally what the court held in this case. That's where we stand right now.
And that's what really brought this home to me. And this is why I started following this case, even when it was before it went to the Supreme Court, is that, you know, I saw this case come out and I'm like, you know, is the court here trying to make medical marijuana users, that people who hold this medicinal medical marijuana card, a protected class? I mean, you think about, I do employment law. So I think about, you know, all the protected classes, you know, race, gender, age. And now I'm thinking medical marijuana users, you know, can that be? Is the court really going to come down to that? You know, and I'm thinking, well, it's illegal on the federal side. You know, other states have different laws. I mean, this Compassionate Use Medical Marijuana Act sits in New York. It sits in New Jersey. I know those two states often mirror a lot of their laws, but Pennsylvania does not have that, you know, same type of law. So I'm thinking, you know, which is why I started following this case, is that what are the implications? And then, you know, waiting for the Supreme Court case to come out. I know there's other cases we'll talk about a little bit, you know, the Amazon case.
Yeah, sure.
But what's going to happen? Are they going to actually deem these people protected class? And that's not what the court did. The court actually, you know, punted it back down so that Mr. Wild can bring a lawsuit under the laws against discrimination, and then it's sort of see what the court does after that.
Right.
Is that the right assessment?
I think that's absolutely correct. And, you know, when we're talking about protected classes, those are specifically enumerated, you know, classes of individuals that the legislature decided when passing and amending these anti-discrimination laws. Really, and I think from a conceptual standpoint, somebody who is prescribed medical marijuana does suffer from a disability, which is very broadly defined underneath the law against discrimination. So,
Brian, what do you think about that?
Yeah, so I agree with both of your assessments, right? We haven't seen any declaration that use of medical marijuana as prescribed through a lawful state program puts you into this sort of protected class. But I think what's going to be interesting is to see the way that it plays out in the future over the next months, in the next several years. And are we ultimately going to get to a place where they very much appear to be a protected class, albeit without having been declared as much by the legislature or you know, the courts? And I think that's the trajectory that I see it going, because I think the Supreme Court was wise to sort of narrow its opinion, and they want us to look at each of these on a fact-by-fact basis. And I think that's proper here, right? There are a lot of factual nuances to each of these claims as they're going to start to arise. But over time, we're going to see a broader picture that's being painted, right? And when we see that broader picture, I think that picture is going to tell us that although perhaps not declared as such, we're looking at people that are going to be sharing in rights very similar to a protected class.
Yeah, and I would only add to that.
Oh, go ahead.
The only thing I would add to that is this. What our goal was in oral argument before the Supreme Court was to make our position clear that medical marijuana should be treated as the same as any other type of medication. And so when we start talking about medicine users becoming a protected class, now we're going to have so many subsets. Are people who take anti-anxiety medications, are they a protected class now? You know, really what we were getting at is this marijuana is the treatment for the underlying disability, which is a protected class. And so, you know, I think when we're talking about medical marijuana and when we're trying to wrap our head around all the changes that are coming, I think it's best to look at it as another medication. It's a prescription drug. It's controlled. A physician has to evaluate you. They have to make certain findings before you're eligible. And so that's the way that we've viewed this case from the beginning. It's a disability discrimination case, and he just happened to be using medical marijuana instead of opiates or any other type of prescription.
But they impair your abilities, and your capabilities. I look at the Wild case. Mr. Wild, he was a cancer patient. He was using the drug after work. I don't know in what form. I don't know if that ever came out in the case, during argument or anything like that. And again, he didn't want an accommodation for his use of medical marijuana. He just wanted to be able to use it when he was out of work, off site, wasn't doing anything. But there's so many people that have the medical marijuana card, they can go in and they can say, doctor, I have anxiety, can you give me a card? And I don't think it's that hard. I don't think, I don't know I don't have a medical marijuana card myself, so I don't know what the test is or what they look for. But if I have anxiety and they give it to me, who's to stop anyone from using it at work? Who's to say, you're not supposed to be using Oxycontin and working on heavy equipment, things like that.
Well, the Compassionate Use Act, as amended by the Jay Koenig Amendment, prevents that.
Yeah.
And what it says is they don't have to accommodate the use in the workplace during work hours. That's a clear statutory pronouncement. I think that's a reasonable line to draw. I think anybody could agree that we don't necessarily want people going into work in an altered mind state. But
and Wendy, if you look even outside New Jersey, right, you look beyond that to other states that are all addressing some similar things to what New Jersey is addressing, there seems to be consistency in carving out this exception where, if safety could be an issue, right? And if you're actively under the influence in a profession or an occupation where, alertness and safety are concerned. So New Jersey is not the only state that has sort of view that to be important, right? And we're seeing that across the board. I think different states are defining things differently, be it by virtue of the type of the work that you're doing, or if it's just actively referring to being under the influence or the use of. But I think we're seeing a lot of states in agreement on this front.
Well, look at the Amazon case that just came out, and that's actually was pending while they were waiting for the Wild case to be decided from the Supreme Court level. And in the Amazon case, the worker was subject to a random drug testing. So if you're subject to random drug testing, okay, you could say, well, I operate, sometimes, if I'm a warehouse worker and I'm taking out, packages and boxes and using heavy, forklifts, heavy equipment. How do you know if they're using it at work or not? They could say, well, I only do it outside of work. I have my card. And what's to prevent them from, if they're terminated, like this Amazon worker was, from being excluded? I think that's really why this case really struck home to me, is that you almost are making them a protected class.
Yeah, and it raises an important question too, which is I think the direction that we're seeing this going is, rather than are you permitted to be a marijuana user, right? A medical marijuana user. I think the bigger question that we're going to see is who's to be the arbiter of determining whether or not you appear to be under the influence while you're at work, if that's something that's been permitted, right? So who's making that conclusion? How are they making that conclusion? And then what are they obligating their employees to do after making that conclusion, right? I think that's going to be the area where things get really sticky moving forward, because it's a matter of process. And I don't think anybody has that sorted out just yet.
What about just federal workers? Do you think that there's going to be any change on that with regards to the changes with the Compassionate Use Medical Marijuana Act?
Said for federal workers?
Yes.
Well, I think really what is applicable to federal workers here is all the DOT regulations, right? And what the DOT regulations essentially say is, if you have a commercial driver's license and you are subject to these random drug tests, you cannot test positive for a Schedule 1 drug. That is a disqualifying event. Now, that raises the question of when we're talking about reasonable accommodations, are there reasonable accommodations short of terminating somebody with a CDL that may be applicable? And you know, to touch on Ryan's point, that really is a fact-sensitive analysis, and it varies from case to case. So where an accommodation of, you know, maybe a 2 or 3 week medical leave to allow the employee to clear this out of their system and perhaps talk to their doctors about a different prescription, that may be a reasonable accommodation even for people who have those safety sensitive positions. So there's a lot of moving parts that are left to be addressed, you know, and there's going to be some cases coming down the pike that are going to test those for sure.
Yeah,
Didn't one of you say you have a case?
I do.
Can you talk about a little bit?
I'd prefer, I mean, I could tell you a little bit about the facts. My client was, he had a previous injury and a construction job. And for many years, he treated it. He had surgical intervention, treated it with prescription opiates. And over time, the opiates had a terrible impact on him. The side effects were just terrible. There's, of course, physical dependency with opiates. And so after a while, he went to see a pain management specialist who felt that he would be the perfect candidate for medical marijuana because of these underlying injuries and because he's having issues with the prescribed opiates. And so he started on medical marijuana in June. Around that same time, he was hired as a equipment operator at a company. And essentially about 4 months into him working there, he was selected for a random drug test. And at the time he gave his urine sample for the drug test, he told the safety coordinator, look, I have this medical marijuana card. I'm going to test positive. I don't know what you want to do, but here, make a copy of my card for your records, whatever you want to do. So of course he does eventually test positive as he knew he would, and as his employers knew he would. But that test takes approximately 3 weeks to come back. Now, in the interim, the employer allowed him to continue operating this equipment for 3 weeks after he had told them, I'm using medical marijuana. And so, you know, that's an example of the type of facts that may impact the reasonableness analysis when you're talking about accommodations. You know, if their reason for terminating him was, oh, you know, we're worried about the safety. Okay, well, why weren't you worried about the safety for the 3 weeks after he told you he was using it? You know, so there are factual circumstances like that will differ from case to case.
And my understanding, I went to a seminar and they had a pain management doctor on there, and they said, you know, there's things that you see out on the streets. You know, I went to this market in Philadelphia, the Reading Terminal Market, and they had all kinds of CBD oils and products, but the pain management products that they have, like the real stuff, they said, I mean, they do affect your impairment. You are considered, I guess, high, you know, and I don't know, you know.
And sure, and I think that's very similar. Sorry to cut you off, Ryan.
Sure.
I think that's very similar to any other prescription drug, though. You know, we have mind-altering pharmaceuticals that we take on a daily basis, you know, and depending on your underlying condition, look, if you take Xanax and you don't need Xanax, you're going to feel a little loopy. But if you're anxious and you take Xanax, it takes you back to baseline, you know. And so I think there are a lot of things that we need to distinguish when we're talking about, you know, are they under the influence? Does it affect your ability to perform your job? Yeah, those are important questions to ask. But for somebody who's in excruciating pain, who takes, you know, a certain milligram dosage of an edible marijuana medical treatment, and that takes them to baseline so that they can actually get through their workday, that may be a circumstance where, you know, are they slightly under the influence? Perhaps, but are they able to do their job?
And Wendy, to build off that point that you were making as far as opiates are concerned, you know, Dylan and I both practice in the white collar criminal defense context as well. And I'm sure he's seen as well as I have, is that if we're talking pain management clinics and physicians, I'm sure we both have clients that fall within that realm and have fallen victim to the ire of the feds, right? So the U.S. Attorney's Office, the Department of Justice are actively looking to address what, it's no secret, there is an opiate epidemic, right, throughout the country. And at the same time, while the federal government is pushing to push back on that, you have to wonder how that's going to color things moving forward as it pertains to medical marijuana. Is this really the fight that we should be putting up against? And can you actually marry those two policy goals at the same time, right? So if anything, I think if we're eyes wide open, you're looking at medical marijuana as something that perhaps greater concessions should be being made because of the fact that perhaps it's distinguishable from things like these intense opioids that could knock somebody off. You know, it's not just if you're using it before you go into work. If you use it the evening before and it's strong enough, you're likely to still be impaired even in that next morning when you headed into work.
Yeah, I think somebody was brought up a subject before about, you know, what if you had, you know, 4 scotches the night before, you know, and then maybe you're a little hungover the next day. Is that an impairment, you know, to your work capabilities?
I'd say
absolutely. Is that
absolutely.
something similar?
No, I've seen.
Not that I
I've seen
drink
people
4
hungover
scotches and when I go
before,
home from work. This is a question to either one of you. Do you think that employers then should require employees right away to disclose whether or not they have medical marijuana cards?
Well, I don't think they can do that, frankly. I mean, that right now, the way the law against discrimination is worded, asking people about their disabilities at the interview stage or even in the beginning of their work and making a decision to take adverse employment action because of that is actionable. You know, so you know, if an employer was to say, hey, you know, I really want to hire you, but by the way, do you use medical marijuana? And then they decide not to hire that man, they're looking at a law against discrimination suit.
Sure. I'm inclined to agree with Dylan. I think there's other mechanisms that at least that employers can start putting in place. One of them is just having, you know, a more detailed, let's say, employment agreement and expectations as far as policies are concerned. You don't just say, you know, we don't permit illegal drugs, right? That could be ambiguous right now. Is marijuana legal? Is it illegal, right? Greater specificity, at least so that they're fronting these issues with prospective employees up front. I think that could allay a lot of the concerns that we're seeing moving forward, but it's not going to avoid all of them, right? There's still going to be somebody that goes, signs off on their employment agreement and starts working and has a medical marijuana card. And the other thing that you raised, which is kind of interesting, and it's something that you see in the Amazon case pending, is there's a lot of questions over as far as what's the right process or protocol here for both an employer and an employee. Do I disclose that I have the marijuana card up front? Do I not? Do I take the drug test or do I refuse? Do I wait for a positive result to come in, or do I front the issue that I have this card and that I'm expecting a positive result, right? I don't think we've clarified exactly the right way for this to play out because there hasn't been enough litigation to figure out exactly the way that this is supposed to play out. And as a result, you have all these different variables in every case that's making it difficult for the courts to just make some sort of broad declaration.
Sure, because isn't that a catch-20? I mean, okay, you don't disclose because, again, it's not, and the court has left this, like they're not, medical marijuana users are not a protected class, but okay, if I'm a company that randomly drug tests people, okay, I don't disclose that I have a medical marijuana card, I work, and then, okay, I find out I'm going to be random drug tested on Monday before I come in. Do I tell them that, you know, I ate some edibles, you know, the day before or not? Do I have to disclose it? And then what happens if I say, okay, I'm going to play it safe. I'm going to not disclose that, you know, what I do. I'm going to say, I don't want to take the test. Then you get fired. Then you backdoor it and say, well, no, I was a medical marijuana. I have a card. I can't get fired.
That's an interesting point, Wendy, because that was Justice Patterson's exact question to me at oral argument. She wanted to know.
See, I'm a Supreme Court justice, and I didn't even know
Justice Wendy. So what she wanted to know is, can a plaintiff maintain a failure to accommodate claim under the law against discrimination without specifically requesting an accommodation? And that raised a really interesting point as to what constitutes a request for accommodation, right? Because, you know, normally what would happen is if somebody had, let's say they had a knee injury and their job was a mail carrier, maybe for a month or 6 weeks, they'd be placed in the office and somebody else would walk around and deliver the mail until they were healed. And that would be their accommodation. Please, let me work inside the post office instead of walking around delivering. In this case, what the accommodation you're asking for is the ability to continue using the medication that you were prescribed. And so, trying to wrap your head around when that's appropriate to come up really depends on how comfortable an employee is to share that information, and part of that is going to be, are employers working with employees to accommodate this? Are they giving them that medical leave for safety sensitive positions? When you have a framework where employees feel protected, that they're not going to lose their job because of an unfortunate disability that they're dealing with, then you have a more open line of communication between employee and employer, and you can work through these kind of issues. But if they feel like they're going to be summarily terminated because of the medication that they're using, I think it's fair to assume that nobody's ever going to voluntarily disclose that until the time they absolutely have to, right? At the time of the drug test.
Yeah. We talked a little bit about some technology before we did this podcast, what's out there. And I know that, Dylan, you just shared a recent article with the breathalyzer.
Yeah, that's right, Winnie. There's some exciting innovations coming in that area. I think it was the University of Pennsylvania that developed this initially. It's essentially what they say is it's made up of hundreds of these nanotubes that are able to measure, the level of THC in your saliva to determine what the threshold level is for intoxication. And so they've essentially been studying this for over a decade, and they've come up with this technology now that's supposedly very accurate, but there's still a lot of issues that need to be ironed out with it, but it is promising.
And that's in general one of the biggest hurdles I think facing if you want to go further things from medical cannabis legalization to, let's say, adult use legalization, right? One of the bigger concerns that we're hearing from policymakers is how can we gauge whether or not somebody is under the influence and or to the extent how much THC is in the body active at that time, right? And I think we've seen a delay in the technology behind the progress of the laws, which isn't always the way things shake out. If you look at something analogous to alcohol, we have an Alka-Test or a breathalyzer, and you can tell in an instant what somebody's blood alcohol content is. I don't think we have something directly analogous to that yet for marijuana. And obviously we're talking in the employment context as far as if somebody's under the influence at work, but it also applies in the context of, criminal law and other areas as well. How can you tell if somebody is impaired due to cannabis? And I don't know that we have a good answer for that yet.
What about drug recognition experts? If this came to a case.
Yeah. So Wendy, that's something.
Air quotes for that.
Yeah, that's something that, again, Dylan and I are somewhat intimately familiar with through our criminal defense practices, because a drug recognition expert, or DRE is what they refer to. It is essentially a law enforcement officer traditionally that has been trained and is able to, just by making firsthand observations of an individual, ultimately make a determination that, and I'm sure Dylan would agree, is arguably a medical determination as to whether or not somebody is under the influence of a controlled substance, and even speculate as to what substance that actually is, right? So it's currently being challenged in New Jersey. Some people are questioning the science. Some are saying it's no science at all, right? So perhaps in the past, using DREs would be one mechanism in place to determine, we have this mechanism to figure out if somebody's under the influence of marijuana. Now's not the time to start relying on DREs. So we need to find, on the technology side, we need to find a replacement. Do you agree, Dylan?
Absolutely, Ryan. I mean, the case that Ryan was referring to, State v. Olenowski, did go up to the Supreme Court, and they remanded it to a special master to conduct hearings on the reliability of these drug recognition expert opinions. And I find it almost laughable that they call them experts. The police academy offers a 2-week class for them to become DREs. that's essentially the extent of their training to
Wow.
to impact people's lives by making these medical determinations. It's really bizarre. And I understand that there was a gap, right? There's officers need to be able to protect our roads and highways, and they need to be able to determine if somebody is under the influence. And many times we can just look at somebody and tell that they're on something, right? You look at someone, he's whacked out on something. That's not good enough for criminal cases. You have to show exactly what he was under the influence of. You have to show that that he was under the influence at the time he was operating the car, that it deleteriously affected his ability to drive. These are all standards in a criminal case that, to the state's credit, they have the burden of, and so without drug recognition experts, it's going to be very difficult for them.
We'll put it back in the civil arena. I had a case 2 years ago where the guy who caused the accident refused to get drug tested because he knew he would get tested positive. Now, I don't believe this gentleman was a medical marijuana card holder. I think he used it just for recreational purposes. Said he had, he knew he was going to get tested positive, and that's why he refused to take the drug test. So there was never any proof that he actually had, how much marijuana was in his system at the time. If he was a regular user, smoked up every night for, 10 years, he probably could have been fine. But of course, in my case, the plaintiff's side argued, well, that guy was probably high as a kite when he hit my person, and all of that kind of stuff. And obviously, we filed motions to keep that out. Battle of experts, and the case ended up settling. But that's what I see in the civil arena. How when you deal with these cases, how much is in the system, how much makes somebody high.
Right, and I think
do you have to go into work really with bloodshot eyes?
Yeah, right. I mean, and that's important, and that's something that distinguishes marijuana from other prescriptions, right? Because the half-life of an opiate or an amphetamine is 3 to 4 days, compared to marijuana, which can stay in your system 30 to 45 days. So yeah, there is a need to get science in line with the laws. Ryan's point.
Yeah, agreed.
So what do you think ultimately at the end of this, what do you think is going to be the ultimate case with Mr. Wild and these cases coming down the pike with regards to, the Compassionate Use Act and the laws against discrimination? Do you think these guys are going to be able to just bring suits and survive this? Or do you think that the wrongful termination, he was wrongfully terminated, that's going to be upheld?
Well, I think it's a little early to make that call. So from the procedural history in this case was dismissed prior to any discovery being conducted.
Yeah.
And so the appellate division and the Supreme Court both were working with a barren record. There was no record other than the pleadings. And so, because of the fact-specific nature of these law against discrimination cases, it's really just too soon for anybody to really tell if he's going to have a viable case going forward. There's going to have to be interrogatories, document demands, depositions. And, at that point, after reviewing all the evidence, maybe there is a summary judgment motion that the employer could make that would get them out of the case. Maybe there's not, and the only thing I would say is that the trend in the New Jersey courts has been clear, right? We see more compassion for this compassionate use of marijuana, and our courts are doing, their best to interpret these new statutes as they're being amended. And the trend is clear. The medical marijuana patients are being protected more so now than ever. Even at the federal level, there's talk of descheduling marijuana, which would have a direct impact on the DOT regulations we discussed earlier. This is just a new wave, and I think employers, to be clear, I do plaintiff side, but I also do employment defense work as well. So, I get both sides of the argument here. But I think employers really do need to start wrapping their head around this and figuring out ways that they can work with people using medical marijuana instead of fighting against them.
Yeah, I'm inclined to agree with that. I think the marijuana laws in New Jersey are evolving, and I think it's only going to be continue on this progressive route moving forward. Adult use is probably around the corner in the future in the next year or two. So I think the courts are going to continue to be inclined to support the spirit of this legislation, right? But at the same time, I don't think they would desire to squeeze employers to an unreasonable degree. And I think the solution to all of this is for employers to be abreast of what's happening and proactive about it, right? And take these sort of prophylactics or preemptive measures, whether it be implementing policies or figuring out your game plan in the event one of these instances were to come up, and figure out how you're going to approach it. And I think in time we'll see a process, a traditional process play out for the way these types of potential claims are addressed and resolved. But there's absolutely going to be some growing pains in the process, and I don't think we're going to get past them for probably several years.
Well, and I think to Ryan's point, I think employers, now that we have this Honig Amendment to the Compassionate Use Act with this very detailed drug testing framework, I think employers are a lot more informed now about what's expected of them on that end. And I think that was important for our legislature to do, because when you are expecting an employer to accommodate, you got to let them know how. So I think the amendment that was made this past year, the Honig Amendment, was an extremely important step toward getting us to a point where this is normalized and there could be some standard practices across the board.
And what are some of those standard practices that were listed in the
Honig Amendment?
Amendment, yep.
Well, it basically just gives the employer and employee the exact process of what's going to happen. So now what the statute says is that at the time of the drug test, the employee only has to present the card. And so that would be a request for reasonable accommodation. At the time of you're expected to give your drug test, you give this medical marijuana card. You advise the employer that you're likely going to test positive. And really what's likely going to happen is, instead of being excused from the drug test altogether, it's going to be almost like a line item veto, right? You got this card. All right, we're testing you for everything, but if you come back for marijuana, we're going to, we'll cross that one out and disregard it. But if you have a medical marijuana card and you test positive for heroin, you're gonna have a problem. it's still gonna be a problem.
Yeah. They haven't made exceptions for heroin use yet.
No heroin exception to law against discrimination.
Well, thank you both for coming on to our podcast. I don't know if anyone has anything else to add before we sign off.
No, the only thing I would add, Wendy, is that, I see this, and we did touch on this a little bit already, but the future for medical marijuana and recreational marijuana is pretty much set in stone, right? We know where it's going. Every state is making moves one by one. Eventually, there will probably be a federal framework for this, but in the meantime, I would hope that we can all.
I think we have to get past COVID first.
Right. Yeah. Well. Yeah. We'll get past COVID first, and then we'll deal with this. But I would hope that there would be some more people working together to try to figure this out, instead of fighting each other every step of the way for something that will inevitably occur.
Sure. I guess, Wendy, my final thought would be that, in this conversation, it's come up a few times. Obviously, we're addressing medical cannabis, medical marijuana, and we talk about adult use or recreational on the cusp, whatever you want to call it. I think in the years ahead, it is important, and even now, to make sure we acknowledge that dichotomy. And what we're talking about now is medical marijuana. We are talking about medicine for medical patients that require it out of necessity, right? And there's going to come a time where our conversation is also going to include adult use marijuana, and the laws and the rights pertaining to that are probably going to be very different. And so for purposes of conversations like what we're having today, you need to view these people as medical patients, because that's precisely what they are. And I think when you view it through that lens, you adopt more of, as to borrow the term Dylan used before, more of a compassionate view towards the entire process.
Sure.
Well, again, thank you both for coming on to our podcast. For the listeners out there, be sure to subscribe to our podcast, The Defense Never Rests, and have a good day. Stay safe, everybody.
Okay, thank you for having us, Wendy.
Thanks for having us, Wendy.
Okay.